Hey there. Thank you for being here. I'm sorry my phone died last time, so we are picking up not from a planned break, but a phone malfunction. We are reading Contempt of Court, Turn of the Century Lynching That Launched 100 Years of Federalism by Mark Curriden and Leroy Phillips Jr. We're on page 165. I told them I would not discuss this matter privately with anyone, and Mr. Whitaker is not here today. Pardon said he didn't care to talk to Mr. Daniels. I said they must bear in mind that you must give such notice on the first day that a motion for a new trial will be filed, which is within 3 days thereafter. You must file your notice stating specifically all the grounds to be relied on. Hutchins then said, quote, Sunday is not counted. Tomorrow will be in plenty of time, unquote. I never said a word, as it was not my duty to advise him. The hearing lasted well into the night. Both sides delivered strong closing arguments. Pardon said the testimony of Judge McReynolds and J.P. Pemberton that they could only remember 1 or 2 Negroes serving on juries during the past 7 years was proof that black people were being systematically excluded from jury duty. And he said Thomas had provided sufficient evidence that the original trial team did not file for a continuance of change of venue or file an appeal because they felt threatened or intimidated by Judge McReynolds, Sheriff Shipp, and the lynch mob. Those 2 witnesses provided sufficient verification that Johnson's right to due process and equal protection had been violated, Pardon said. Pardon said there was also a basic unfairness in how the crime of rape was prosecuted. Between 1900 and 1906, the lawyer told Judge Clark, 17 women had come forward to report they had been raped or sexually attacked. Of these, 14 were black women. In those cases, only 4 men were ever arrested. 2 of those men were released without receiving any punishment, and the other 2 were awarded short prison sentences. The cases involving the 3 white women were handled much differently, Pardon said. In each case, an arrest was made. All 3 villains were black men. All 3 were put on trial. 2 of them were sentenced to die, and the 3rd was given a 21-year prison term. Quote, the law is not being applied equally, unquote, Pardon argued. People are being treated differently in Chattanooga because of the color of their skin, and that is a violation of the 14th Amendment's Equal Protection Clause. The federal government must step in and correct the situation, unquote. District Attorney Whitaker's closing statements focused almost entirely on the separation of powers between the state and federal court systems. The prosecutor argued that there was no evidence that any of Johnson's federal constitutional rights were violated. The prisoner had the chance to appeal to the Tennessee Supreme Court, Whitaker said, but he knowingly waived those rights. The case belonged in state court, and the petition should be denied, he said. After each side had its say, Judge Clark announced he was going to retire to his chambers to consider the matter. Many people thought he would simply issue a ruling within the next day or so, but he told the lawyers and those in the courtroom that he would return with a decision later that evening, because the matter needed to be expedited. The judge suggested everyone get a bite of dinner while he reviewed the law and considered the arguments and testimony presented to him. For 8 hours, the 2 sides had done battle. This day would cause a rift between McReynolds and Shepard that would never be mended. The judge perceived the defense lawyers' attacks on how the trial had been handled as a personal attack against him. It was the first time any lawyer had challenged his competence as a jurist. Shepard felt that he was merely doing his duty as a lawyer in defending a client, and that his ethics required him to pursue this on appeal. He believed Judge McReynolds had made mistakes and Johnson deserved a new trial. Despite attempts by Shepard to state publicly that he meant no personal criticism of Judge McReynolds, the two men would never socialize together again. Similarly, Pardon and Hutchins realized their future in the legal profession in Chattanooga was bleak. Their relationships with the judge and prosecutors were strained even prior to the Johnson case. Now they doubted they or their clients would ever be treated fairly in court. Unlike Shepard's, their status within the legal community and power structure might not withstand a feud with Judge McReynolds. They wondered what would happen if their clients learned that the county's judge hated them. They might not be hired again. 3 hours after he escaped into his chambers, Judge Clark returned to the courtroom. The time was 12:47 a.m. Despite the late hour, it seemed that not a single person had gone home. Every seat in the courtroom was full. The white people sitting behind McReynolds and the prosecutors were confident that the federal judge would rule in their favor and that they would take Ed Johnson back to Chattanooga with them to be hanged. The black people who packed the pews behind the defense attorneys were equally convinced Johnson would be declared a free man that night. Judge Clark was poised to disappoint both sides. Quote, there is an implication here of two things, unquote, he said, speaking very slowly. Quote, that there was great haste in this trial, and that the trial was under a kind of species of apprehension on the part of the counsel, and that counsel were to an extent terrorized on account of the fear of the mob, unquote. The judge said he did not think there was sufficient evidence for him to rule that black people were illegally excluded from sitting on juries in Hamilton County. As to the other claims, he said, they were beyond his control. Judge Clark said Ed Johnson's trial very well could have been a sham. The problem, he said, was that the Sixth Amendment to the U.S. Constitution, which guarantees a criminal defendant the right to a fair trial, does not apply to state court cases. The federal judge said that even if the allegations that the jury was biased, the trial lawyers were intimidated, and Johnson was improperly stripped of his right to appeal were true, he had no authority to intervene. Only Congress or the Supreme Court could give the federal courts the power to take appropriate action in a state criminal case, he said, and they had chosen not to do so. Just as the Hamilton County authorities were smiling at each other and prepared to erupt in self-congratulatory praise, Judge Clark tempered their victory. He did not have the jurisdiction over the procedural and evidentiary aspects of the Johnson case, but he believed he did have the power to issue a stay of execution in the case to permit Johnson's lawyers to seek an appeal to the United States Supreme Court. The March 13th hanging was postponed until at least March 23rd, he said. 10 days should be enough time to allow Pardon and the other lawyers to prepare a petition for the High Court. Chapter 10. The Supreme Court intervenes. Despite not going to bed until well after 2 a.m., Sheriff Shipp awoke before dawn that Sunday. He showered, shaved, and put on the same clothes he wore the day before. An overnight stay in Knoxville had not been in his plans. As the sun slowly peeked over the distant Smoky Mountains, Shipp and 3 of his deputies walked to the Knox County Jail a few blocks away. Per Shipp's instructions, the night before, jailers had Ed Johnson dressed at 6:30 a.m. and prepared to be transported back to Chattanooga. The sheriff and his entourage met Judge McReynolds, District Attorney Whitaker, and others at the train depot for the 3-hour trip home. Although they had won the federal court battle the night before, none of the men were in a particularly good mood. They still felt the sting of the public charges made against them. and even though Judge Clark had ruled in the state's favor, the public officials were extremely unhappy with his decision to stay Johnson's execution for 10 days, pending a possible appeal to the U.S. Supreme Court. The very idea that the U.S. Supreme Court would ever entertain an appeal by Johnson's two black lawyers was considered preposterous. The stay was nothing more than a delay tactic, a maneuver by Pardon and Hutchins designed to give their client a few extra days of life, Shipp told others. But what could be done, the sheriff asked, as he brandished the order by Judge Clark, requiring that Johnson remain in Shipp's custody until March 23rd. McReynolds was even more upset. The realization that a federal judge had intervened and superseded his order, setting the day and time of execution, left him outraged. He took Judge Clark's order, albeit a mere 10 days, as a personal insult and thought it demonstrated contempt by the federal courts for the authority and jurisdiction of the state court system. As the deputies supervised the prisoner in one car, Shipp, McReynolds, Whitaker, and a handful of Chattanooga lawyers huddled around a table in the dining car, sipping coffee, tea, and juice. The members of the group contemplated their next move. Their options seemed limited. They could accept Judge Clark's order and wait 10 days to hang Johnson, or they could appeal the ruling to the U.S. Supreme Court, claiming a federal judge did not have the authority to intervene in a state criminal case, especially when there was no evidence or finding by the federal judge that the defendant's U.S. constitutional rights had been violated. Their final option was simply to ignore the federal court order, publicly declare that it was illegal, and execute their prisoner as scheduled. Judge McReynolds said that he happened only a few years earlier, in a murder case in Georgia involving an Indian. He told his colleagues that lawyers for the Indian defendant had appealed to the Supreme Court for intervention after the trial resulted in a conviction. The federal justices agreed with the defense attorneys, ruling that the state should turn the Indian over to federal authorities because the alleged crime had been committed on an Indian reservation. But only days after the Supreme Court order, Georgia officials decided to ignore the federal court mandate publicly by ordering that the defendant be executed immediately, and he was. Everyone in the train car wanted to know what happened to the Georgia officials. Did the federal government take action against them for violating the Supreme Court order? Were they punished in some fashion? McReynolds said the federal government offered no response, and the action of the state authorities was never criticized by the justices. Nothing was ever done about the matter. The story raised the eyebrows of every person in the cabin. But McReynolds said that each possible solution to the Johnson case was problematic. None of the officials minded waiting extra days before carrying out their revenge on the defendant. But they, especially McReynolds, were indignant that the stay was the result of a federal judge's sticking to his nationalistic gavel in their state court system. Besides, it was an unacceptable precedent to accept federal court intervention in a state court case. However, appealing Judge Clark's order could take weeks or even months. It would likely cause the execution to be delayed even longer. The idea of ignoring the federal court order intrigued them, but no one spoke out for such affirmative action. For Shipp, the problem was more immediate. He held in his hand two separate court orders. One was from Judge McReynolds instructing him to hang Johnson on March 13th, which was just 2 days away. And of course, there was the contradictory order from Judge Clark, telling the sheriff not to execute their prisoner until March 23rd. Both Shipp and McReynolds were unsure as to whether an order issued by a federal judge superseded an order from a state judge in a state court criminal case. The other lawyers had to develop a strategy. The next morning, Shipp would tell the newspapers of his predicament, having two conflicting court orders. Whitaker and a group of private lawyers would publicly say that Judge Clark's authority to stay the execution was in doubt. A couple of the lawyers even planned to call the federal judge to express their opinion. Once the federal court order was undermined, Judge McReynolds would step forward to propose that Tennessee Governor Cox was the only true authority that could rightfully delay the execution of Johnson. That Monday morning, everything went as planned. The two newspapers reported that Judge Clark's stay might not be viable. Even Judge McReynolds publicly disparaged the federal court order in a statement to the Chattanooga News. Quote, "We do not concede that Judge Clark had a right to grant a stay of execution in Johnson's case, or that he did do it in fact. His order was practically this: Johnson is given into the hands of the sheriff of Hamilton County to be kept for 10 days. Unquote. The most surprising source of doubt on Judge Clark's ruling was the federal jurist himself. Several Tennessee lawyers contacted Clark to express their concern that federal judges do not have the authority to postpone state criminal executions. As a result, Judge Clark expressed uncertainty about his own power. He called Judge McReynolds, and the two men agreed they should ask the Tennessee governor to give the prisoner a short reprieve to allow his lawyers to seek an appeal to the U.S. Supreme Court. Following telephone conversations with both judges, Cox did grant Johnson a temporary stay, but only for 7 days, not the 10 days ordered by Judge Clark. The action was clearly a political victory for McReynolds, who could claim he had thwarted unnecessary and intrusive federal intervention and interference in a state court case. He could also claim complete vindication for his own handling of the Johnson case. The governor immediately issued an oral directive to Sheriff Shipp to delay Johnson's hanging, and he promised to send a written order within days. If Judge McReynolds was triumphant, Pardon and Hutchins were befuddled. The reduction of the stay from 10 days to 7 days meant less time for them to prepare their case for submission to the U.S. Supreme Court. They began working around the clock. Meanwhile, Johnson was kept in solitary confinement on the 3rd floor of the jail. No family members or friends were allowed to visit him. His lawyers were permitted one brief meeting with their client per day. As the sheriff prepared the gallows in the basement of the jail for Johnson's execution, and the defendant's lawyers hurried to spare his life, the Hamilton County grand jury reconvened for the first time since it had indicted Johnson for the rape of Nevada Taylor. It was also the last time this particular panel would meet together. Their final order of business was to investigate the attempted lynching of Johnson and the destruction done to the jail the night of January 25th. They had earlier been instructed to learn the names of the men involved and indict them with the most serious charges that could be levied. But the grand jury probe took an unusual twist. Despite the presence of a dozen police officers, deputy sheriffs, and leading local officials, no witnesses were able to identify a single person who had participated in the attack on the jail. Interestingly, not even Judge McReynolds, who had met at length with several members of the mob, could remember the names of the people he saw and spoke to that evening. As a result, the grand jury did not indict a single person for the January 25th incident. However, the panel did issue felony charges against the white man for stealing a horse and against 3 black men for stealing 2 mules. The lack of action brought the ire of the city's black newspaper, The Blade. Quote, "The law and its mechanics have made a farce of our system of injustice. Lily whites have assaulted our public institutions with murderous intentions, destroyed our sense of order, and permitted mob law to rule. The leaders of this community have violated the oaths of their office and their promise to uphold the Constitution. The whites once again demonstrated that the life of a black man is less valuable than a horse or a mule. How can Judge McReynolds or any of the lawmen who so courageously fought the lynch mob suddenly forget the faces they saw and the men they talked to? Is it because Judge McReynolds and Sheriff Shipp want to be elected again? There will be more lynch mobs, and they will be more successful because the lily whites now understand that there is no penalty to pay for their dastardly deeds." Unquote. The harder Pardon and Hutchins worked, the more hurdles and setbacks they encountered. The lawyers split the duties. Hutchins was in charge of gathering the appropriate paperwork to present to the Supreme Court. He needed a certified transcript of the Federalist Court hearing in Knoxville. To purchase the copy, Hutchins twisted a few arms within the black business community for money. Hutchins quickly studied the traditions, rules, and decorum of the U.S. Supreme Court. Neither lawyer had previously been involved in a case that went to the nation's highest court, so they had no clue about its formalities or procedures. They quickly learned that neither of them had the standing to present an appeal to the justices. Only a member of the Supreme Court bar, who has been formally sworn in by a justice, can appear before the court as an attorney in a case. This obviously led to another dilemma. Only a handful of black lawyers had been admitted to the Supreme Court bar. Those black attorneys had been co-counsels on cases debated before the Supreme Court. No black man had yet argued before the High Court himself. Fortunately, Hutchins knew one of those black lawyers, Emanuel D. Molyneux Hewlett, an 1877 graduate of the Boston University School of Law. Hewlett had practiced law in Washington, D.C. since 1883. Not one to shrink in the face of racism, Hewlett handled many of the city's high-profile murder cases that involved black defendants. He frequently blasted police for the unjustified detention of black people, simply to improve their arrest statistics. In 1890, President Benjamin Harrison appointed Hewlett Justice of the Peace. So impressive was Hewlett's knowledge of the law that he was reappointed to the position by Presidents Grover Cleveland, William McKinley, and Theodore Roosevelt. Hewlett was involved in several cases that were appealed to the U.S. Supreme Court and had officially been sworn in as a member of the bar. Hutchins had met Hewlett in Atlanta during a convention involving black professionals in the late 1890s, in which both men were speakers. They became instant friends, united in the support of W.E.B. Du Bois and the civil rights leaders' aggressive and confrontational philosophy. The two lawyers had traded letters in years since their initial meeting, but they had not seen or talked to each other in more than a decade. That changed on Tuesday, March 13th. Realizing he and Pardon needed a member of the Supreme Court bar to join their team, Hutchins telephoned Hewlett at his judicial offices in Washington. After exchanging pleasantries, Hutchins got right to the point. He explained the case, told about the federal court's habeas corpus hearing, and their desire to appeal to the Supreme Court. They had only a week before Johnson would be executed, so expediency was priority one. Hewlett was astounded to hear about the handling of the case in the state court. The conduct of the judge, prosecutors, jury, and even the defense attorneys had been inexcusable. There was no doubt that a violation of Johnson's constitutional rights had taken place, he said, and the case should definitely be appealed to the High Court. Just then, Hutchins heard his friend take a deep breath on the other end of the telephone line. Hewlett's hesitancy served as a reality check. The justices had never agreed to hear a state criminal case on federal constitutional issues involving the right to a fair and impartial trial, Hewlett cautioned. But Hewlett understood the potential that rested in the Johnson appeal. This case was unlike many of the prior cases, in which the Supreme Court had been faced with many of the same issues. The previous appeals before the High Court involved alleged procedural errors. all claims that were vigorously disputed by prosecutors as mere technicalities. By contrast, the Johnson case was replete with many undisputed facts demonstrating the denial of a fair trial. There was an official federal court record from the hearing in Knoxville detailing the misdeeds and outrages that had occurred during the Johnson trial. Evidence that the defendant had been denied a fair trial was undeniable. But just as important and explosive, Hewlett thought, was the strong proof that Ed Johnson was actually innocent of the crime. This was not a dispute over whether the prosecutors had met their burden of proof. Here was a case in which an obviously innocent man had been railroaded through the state criminal justice system and now faced death at the hands of the very men who had stripped him of his dignity and rights. It represented a substantial dilemma for the Supreme Court. Quote, "Wow," unquote, Hewlett responded. Quote, "I think we may have a chance here," unquote. Hewlett told Hutchins that there had been speculation for many months among prominent black lawyers and like-minded white lawyers that the time might be right for the court to be presented with such an argument. There had been rumors that several members of the Supreme Court had grown disenchanted, even disgusted, with the lack of professionalism in the state courts. Hewlett said certain justices were known to believe that black people and poor white people were not being afforded adequate legal protections and due process in state criminal cases. Quote, "A case with the right facts and the appropriate argument just might make the difference in persuading the court," unquote, Hewlett said. The two lawyers agreed to talk again the next day. Hutchins wanted Hewlett to speak with Pardon, who would most likely be the person to come to Washington later that week. Before Hewlett hung up, he again warned his friend that the chances of victory for their case were slim. Pardon, meanwhile, was facing another dilemma, this time from a surprising source. At the suggestion of his law partner, Pardon called W.E.B. Du Bois to seek advice on how they should proceed. Du Bois, who surrounded himself with some of the brightest black lawyers in the country, was the first African American to have received a doctorate degree from Harvard University. A few years after the Johnson case, Du Bois was to send a group of lawyers around the country to prosecute and defend cases they believed important to the interests of African Americans. He would organize a network of black lawyers, doctors, religious leaders, and politicians that reached into every state, fighting for civil rights at the local, state, and federal levels, working to improve black people's influence in government, and challenging segregation at every turn. The group he helped found became known as the National Association for the Advancement of Colored People, the NAACP. Pardon hoped to avail himself of some of the expertise gleaned by Du Bois. He thought the prominent scholar would offer tips on how to develop the strategy or possibly give instructions about arguing their case. He sought guidance and support. Instead, Pardon felt his knowledge of the law was being questioned, his motivations under siege, and his commitment to civil rights attacked. Du Bois was familiar with the work done by Hardin and Hutchins in Chattanooga. He praised them for fighting for Johnson's life when everyone else had condemned the defendant to die. However, he was fearful the two lawyers did not have the expertise or the experience to take the Johnson case effectively to the U.S. Supreme Court. The case was much more important than just the life of Ed Johnson, Du Bois told the Chattanooga lawyer. It was a case that could change history. Pardon, Du Bois insisted, was not up to the task. Pardon and Hutchins should turn the case over to more experienced lawyers, Du Bois said, or they should find a more prominent white lawyer to present the facts and argument in Washington. A prominent white attorney would be more readily accepted and respected by the federal justices. For the future of the black race, the Atlanta civil rights leader pleaded with Pardon and Hutchins to resign as defense lawyers in the Johnson case and allow white attorneys with more knowledge, experience, and influence to take the lead. If they refused to step aside in the case, Du Bois suggested, this might demonstrate that they were more interested in self-promotion and gratification than in seeking justice. Stunned by the brief conversation, Pardon felt his ability and his integrity as a lawyer had been challenged. White lawyers had abandoned Johnson when he needed them most, and they were part of the reason he was days removed from a hangman's noose. Though Pardon had promised Du Bois he would immediately discuss the request with Hutchins, he had no intention of stepping down from the case. He told his co-counsel about the conversation, but made it clear he would never agree to be replaced as lead lawyer. He may not have wanted the case in the beginning, but he was determined to follow it through now. Pardon also ignored his pledge to Du Bois to call him back later that day, and when Du Bois called numerous times over the next 2 days, Pardon refused to come to the telephone. For Pardon and Hutchins, the days of the week blended into one another. Hutchins didn't eat for 3 days and slept in his clothes. Pardon napped on the floor in his office for an hour or two a night. His eyes would ache in need of sleep, but the adrenaline rush of trying to save his client was more than sufficient as a stimulant. Late Wednesday night, Pardon was alone in the office scouring law books for last-minute inspirations and guidance. He read and reread the federal statute on habeas corpus appeals. He meticulously sifted through Supreme Court rulings, hoping to discover some forgotten precedent that would help his case. About 1:30 a.m., Pardon heard a noise outside the 4-room wood-frame building he and Hutchins rented for office space. He thought it sounded like people running. Then he noticed the smell of smoke. Grabbing his coat, Pardon cautiously opened the back door of the house. With no one in sight, he slowly walked around to the side of the building where he had first detected the smoke. As he rounded the corner, he saw the flames. At that moment, people came running out of the house next door, screaming in a panic. Smoke had filled their home, too. Fire streaked around the ground and up the side of the wall. Pardon was soon joined by 2 other men in beating down the fire with blankets and buckets of water. Fortunately, they had discovered the flames quickly. Within minutes, the fire was extinguished. Nearby, the men discovered a gas can that the arsonist had used to start the blaze. Pardon shook his head in utter disbelief and frustration. The vigilantes had come to disrupt his efforts, destroy his work, and discourage his commitment. Instead, they had set fire to the wrong building and nearly killed his neighbors in the process. An hour later, about 3 a.m., Pardon's wife, Maddie, walked into his office in tears, accompanied by 2 of their neighbors who were carrying shotguns. While Pardon embraced his wife, the 2 men explained that someone had thrown rocks through the windows of their house and had fired several gunshots inside. This time, they had not chosen the wrong house. Maddie was terrified but unhurt. Pardon spent the next hour comforting her. The 2 neighbors stayed until dawn to guard the couple. This experience only made Pardon more determined to seek justice for his client. Unaware of the events of the night, Hutchins made his initial appearance at the law firm about 8 a.m. He was all smiles and immediately announced he had raised enough money to pay for the 68 pages of federal court testimony taken at the hearing in Knoxville. Hutchins said Judge Shepard and a few other white lawyers who were sympathetic to their cause had given him the money. After receiving a full briefing on the fire next door and the attack on Pardon's home, Hutchins suggested his law partner take his wife to Atlanta for safekeeping and offered to take the petition to Washington himself. Pardon said he would find a safe place for Maddie while he was gone, but he intended to see the case through to the end. He would not be intimidated by racist thugs. By late Thursday afternoon, Hutchins had obtained a certified copy of the federal court's transcript. complete with Judge Clark's signature. The two lawyers put the final touches on the paperwork they planned to submit to the Supreme Court. Louis Shepard reviewed the petition for accuracy and thoroughness. The packet included the petition for writ of habeas corpus that the defense attorneys had filed in their petition for habeas corpus before Judge Clark in Knoxville, along with the final order and the transcript of the hearing Judge Clark had conducted. Pardon then took the petition to the jail for his client's approval. On the official papers that would be presented to the Supreme Court, next to the typed words that spelled his name, Ed Johnson took an ink pen and marked an X. Pardon hugged his client and the two men prayed. Pardon asked God to have mercy on his client, to protect him, keep him safe, and prepare him for the future, whatever it might hold. Johnson's prayers was much shorter. He simply requested that God safeguard his lawyers and their families. Minutes later, Pardon boarded a train for Washington. He would be gone 4 nights, possibly more, if the Supreme Court decided to conduct some kind of immediate hearing on the matter. He left town with the confidence that he and Hutchins had done their best to represent their client. He also felt comforted about the safety of Maddie. The Reverend T.H. McCallie had heard about the incidents at Pardon's home and office. That morning, the aging educator and minister visited with the couple to offer his apologies and support. When he learned Pardon was traveling to Washington, McCallie suggested that Maddie stay with his family at their farm on Missionary Ridge. She would be safe there, he said. Heartened by the outstretched hand, the Pardons accepted the offer. After Pardon boarded the train in Chattanooga, it passed through Knoxville and Johnson City, then steamed into Virginia to stop in Bristol, Roanoke, and Richmond. He was unable to get any sleep. His mind developed every possible scenario that he would face at the Supreme Court. He practiced what he would say over and over again. When Emmanuel D. Molyneux Hewlett arrived at his law offices early Friday morning, Pardon was waiting nervously. The two men had much to discuss. While Pardon sipped a cup of hot herbal tea, Hewlett scanned the petition, reading the highlights. The testimony and allegations were as egregious as Hutchins had told him on the telephone. It was obvious that Johnson had not received a fair trial, and equally apparent to Hewlett that the defendant was most likely innocent. This was an important point to assert, Hewlett said. Pardon spent much of the day asking the more seasoned lawyer and judge about the Supreme Court, its rules, decorum, and procedures. How many justices would be present? How much time would they get? Would the justices ask questions? What did they think of black lawyers? Were any of them from the old Confederacy? Would they agree to hear the case? Would they rule right away or wait for a few days? Could one justice make such a decision, or did it take all 9? Hewlett answered most of the questions, but confessed they were exploring new legal territory. The Supreme Court had adopted its own set of rules in 1790 and had added to them many times since. The rules ranged from one who may file briefs in a case, time limits on filings, and the days and hours when oral arguments would be heard, to the size of paper, number of pages, and even the color of the paper of the petitions and briefs filed with the court. There were no written regulations about dress, though Hewlett suggested they wear a morning coat or a frock coat, a wing collar, a dark necktie. He said business attire was expected. Court started at noon on weekdays and sometimes on Saturdays. Each side was allowed 2 hours to argue its case, Hewlett told Pardon, but lawyers could take more time if they asked in advance. Hewlett gave the young lawyer a copy of Rule 5, which states that a lawyer seeking permission to present a case to the justices must be licensed to practice law in a state for at least 5 years. Unlike today, a lawyer in 1906 did not have to file a written application to be admitted to practice before the Supreme Court. Instead, an attorney was sworn in as a member of the Supreme Court bar by a justice only after being recommended by another lawyer who was already a member. The rules also required that lawyers seeking admission to the bar be of good moral character and have no disciplinary penalties on their record. Hewlett had already taken the oath and would make the motion to the court that pardon be accepted, a procedurally routine event. Even so, the thought of being admitted to the Supreme Court bar sent chills up Pardon's spine. Rule 38 of the Supreme Court sets the fees for filing an appeal with the court, but Rule 39 waives those fees for litigants who are poor and cannot afford to pay. Ed Johnson certainly qualified as indigent. The court also required lawyers to file 25 copies of each brief with the Supreme Court clerk at least 6 days prior to argument. The briefs have to be submitted on legal-sized paper, 8.5 by 14 inches. The paper had to be white or a light shade of gray. In emergency petitions such as this, only the parties seeking the immediate intervention would be heard by one of the justices in chambers. The proceedings were described legally as an ex parte hearing because only one side in the case was present. Hewlett said that he and Pardon might be asked to offer a brief synopsis of the case, as well as answer any questions the justices would have. A full hearing in which both sides made extensive arguments to the court would not take place for several weeks or even many months. But with each answer, Hewlett inserted the disclaimer that the court might choose to deny the request for hearing. Pardon listened intently as the elder lawyer spoke. He peppered Hewlett with every question he could think of and jotted down notes of the things he wanted to remember or believed to be important. There was so much to learn in less than 24 hours. Pardon knew there would be little time to sleep that night. The approach they should take, Hewlett said, depended upon which justices were in attendance. The bad news was that the Supreme Court seldom agreed to hear a petition for habeas corpus from the state courts. The justices had shown no inclination to interfere in state law enforcement matters, and they certainly were no friends to criminal defendants. Though the court had aggressively expanded the federal government's role in the regulation of commerce throughout the country, it displayed no similar willingness to expand individual rights and liberties under the federal Constitution. Even as Hewlett depicted the dim reality of the situation facing Pardon and his client, he also offered a slight hope. The Johnson case had been tried in Tennessee, which in the federal court system resides within the jurisdiction of the 6th U.S. Circuit, along with Kentucky, Ohio, and Michigan. In 1891, Congress created federal circuit courts of appeal to review judgments and verdicts from the federal trial courts and habeas corpus appeals from the state courts. The appeals courts were designed to relieve the Supreme Court of the ever-increasing caseload. The Supreme Court then, and now, designated one justice to hear emergency appeals from each circuit and to be a liaison between the High Court and the lower federal courts. That person for the 6th Circuit in 1906 was Associate Justice John Marshall Harlan of Kentucky. If Justice Harlan was available, the rules of the court required that he be the justice to whom they would make their initial presentation. However, Hewlett said, Another justice could be given the case if Harlan was unavailable or ill. And it was also possible that, because the court was actually in session hearing cases in March, and near the end of its term, all of the justices would be present to decide on their initial request. In all probability, however, the case would come before Justice Harlan, and that had Hewlett encouraged. The black lawyer knew the elderly justice personally, and considered him an honest and open-minded jurist. In addition, he had done a considerable amount of research on Harlan for a class on the Supreme Court he frequently taught at Howard University's law school. Hewlett's analysis was simple. If any of the 9 justices would be sympathetic to Ed Johnson and outraged at the state court's handling of his case, it was Justice Harlan. Harlan was born into privilege in 1833 in Boyle County, Kentucky, a rural community in the center of the state. He was named after Supreme Court's first Chief Justice, John Marshall of Virginia. His father, a lawyer and staunch member of the Whig Party, which advocated a strong national government, held several elected positions, including State Attorney General and Member of Congress. Political activist Henry Clay was a close friend of the family. After graduating from Center College in his hometown of Danville, Harlan studied law at Transylvania University. He received his law license in 1853 and practiced civil and criminal law several years with his father. Harlan seemed destined for politics, too. However, the Whig Party evaporated following the deaths of Henry Clay and Daniel Webster. After a brief stint with the Know-Nothings, Harlan joined the ranks of the Republicans. Harlan's family had owned slaves, though the justice would later describe slavery as a, quote, peculiar institution, unquote. But when war broke out between the North and the South in 1861, Harlan wore Union blue and became a colonel in the U.S. Army. At the end of the war, he returned home and was elected the Attorney General of Kentucky. Twice he ran for governor as a Republican, but the party remained weak in the state and he was soundly defeated both times. At the youthful age of 44, Harlan became the beneficiary of what was obviously a political payback. As a member of the Republican National Convention in 1876, he became a key swing vote that gave Rutherford B. Hayes the presidential nomination. A year later, President Hayes rewarded Harlan with an appointment to the U.S. Supreme Court. Harlan had been on the court for 36 years when Noah Pardon walked in that day. He was the oldest member of the court and its longest-serving member. As a politician in the Bluegrass state, Harlan was a critic of Lincoln's Emancipation Proclamation, which he denounced as, quote, unconstitutional and null and void, unquote. But by the early 1870s, his public statements on slavery and equal rights had evolved. After he was confirmed to the Supreme Court, which provided the security of a lifetime appointment, he actually became a strong advocate for civil rights. He called slavery the, quote, most perfect despotism that ever existed on this earth, unquote. He labeled men who belonged to the Ku Klux Klan a, quote, band of murderers and assassins, unquote. When asked about his transformation, Harlan stated, quote, let it be said that I am right rather than consistent, unquote. The justice berated the other members of the court for upholding racial segregation in public facilities. A social principle, he contended, was nothing more than a, quote, badge of slavery, unquote. Harlan believed that the 14th Amendment and civil rights laws passed by Congress following the Civil War appropriately granted the federal government the authority to protect and promote the rights of former slaves. However, The elderly justice had been unable to convince a majority of the other members of the court of his more liberal ideology. Harlan's views were never stated more clearly than in 1896, when the Supreme Court reviewed the case of Plessy v. Ferguson. When the High Court held that segregation of people by race was constitutional, Harlan issued a scathing dissent. To Harlan, the equal protection rights granted under the 14th Amendment belonged to the person, not society. Quote, "Our Constitution is colorblind," unquote, he stated in one of the most quoted Supreme Court opinions of all time. Quote, "The arbitrary separation of citizens on the basis of race, while they are on a public highway, is a badge of servitude wholly inconsistent with the civil freedom and equality before the law established by the Constitution. It cannot be justified upon any legal grounds. What can more certainly arouse race hate? What can more certainly create and perpetuate a feeling of distrust between these races than state enactments which, in fact, proceed on the ground that colored citizens are so inferior and degraded that they cannot be allowed to sit in public coaches occupied by white citizens? That, as all will admit, is the real meaning of such legislation. The thin disguise of, quote, equal, unquote, accommodations for passengers in railroad coaches will not mislead anyone, nor atone for the wrong this day done," unquote. What many people in 1896 or even 1906 did not realize was that the Plessy case and subsequent cases involving racism were personal to Justice Harlan. He had a half-brother, Robert Harlan, who, like Homer Plessy, was 7/8 white. Robert was 16 years older than John and raised in the Harlan home. As a result, John could see and experience firsthand the prejudices and hardships faced by his half-brother. Over the years, he came to believe that it was legally and morally wrong to discriminate against a person on the basis of race. As a lawyer, Harlan believed that justice under the law was a divine tool given to people by God as a means to regulate or govern themselves. He believed that the law was a part of the fabric of the universe, and that God had blessed the court system as the orderly means by which people settled their disputes. Being a lawyer was a heavenly calling, as was being a minister, a missionary, or an evangelist. Justice Harlan's view of the world was that of an old-fashioned Presbyterian, which was exactly what he was. He saw society and morality in black and white. There were rights and wrongs, and he believed the purpose of the written law was to determine the difference. One of his best friends on the court, Justice David J. Brewer, once said that Harlan went to bed every night with, quote, one hand on the Constitution and the other on the Bible, safe and happy in a perfect faith in justice and righteousness, unquote. On the personal side, Harlan was equally as colorful. He chewed burley tobacco and drank Kentucky bourbon. He loved playing golf, watching baseball, and wearing outrageous clothing. Though he would curse at the slightest irritation, he fell to his knees nightly to seek forgiveness, guidance, and perseverance. To emphasize Harlan's eccentric character, Hewlett told Pardon a story that had been repeated around the Capitol many times. It seems that when Harlan was a young man, his cousin was charged with murder. Every morning of the 3-day trial, Harlan and another cousin sat in the front row of the courtroom, directly behind their relative, with loaded pistols in their holsters and knives in their hands. Harlan and his other cousin feared their friends of the victim would try to kidnap his cousin from the courtroom to lynch him, and they vowed to fight against any would-be lynch mob members. In the end, Harlan's cousin was acquitted of the charges. That Friday afternoon, March 16th, the two men walked several blocks to the U.S. Capitol. They passed through security and into the meandering hallways under the Great Dome. They eventually found their way to the clerk of the U.S. Supreme Court and filed the necessary paperwork with him. The clerk quickly read through the request, scanned the materials to make sure they were complete, and told the lawyers to return the following day. The justices were all in town and hearing cases, he said, but he wasn't sure which one or how many would review their petition, and he couldn't say for sure that the court would want to hear from them at all. Even so, the clerk told them to be present the next morning in case the court had any inquiries. Hewlett and Pardon agreed. Hewlett had other business to attend to, and Pardon needed to send the telegram home to let his wife and Hutchins know he had arrived safely, and that the petition had been filed. The two lawyers agreed to meet the next morning on the steps of the Capitol. Back in Chattanooga, time was running out. Tensions were high. Sheriff Shipp and Judge McReynolds were trying to calm public restlessness by assuring people that Johnson would die as scheduled on March 20th. The chances of the U.S. Supreme Court's intervening, they told their followers, were extremely slight. People here are decidedly anxious as to whether Johnson is to suffer death for his crime next Tuesday, or escape for an indefinite period of time by reason of intervention by the court at Washington. More unrest on the subject exists than was anticipated when Johnson was brought back to the county. The condemned Negro has experienced religion. He became pious during his incarceration at Knoxville. He declared on the way home that he was ready to die and would be ready to die now as any other time. In the county jail, here he is confined apart from the other prisoners. Only occasional visitors live in his solitude. He declares that he is alone with his God and cares not for any other company. Johnson is often reminded of the grim instrument of death that waits in the basement of the jail for the word that fixes the final hour of his life, but it seems to have no terror for him. Of late, the Negro has posed for several pictures. Aside from a restless of the eye, the Negro's nerve is keeping up in surprising manner, and officials at the jail are predicting that he will go to his death as calmly as he faced the victim of his crime when he sat with hand raised to heaven and denounced him as her assailant. Johnson is confined on the second, third floor of the jail and is yet not provided with a special guard. He is talkative, and when any of the guards approach his solitary cell, he persists in chatting with them. He seems a little moved by the fate, which seems to be unavoidable for him now. Quote, Chattanooga Times, March 16, 1906. Chapter 11. Gallows Disappointed. With his scheduled execution less than 48 hours away, Ed Johnson was in excellent spirits Sunday morning. He chatted with friends, recited his Bible, and ate the biscuits and gravy, grits, served to him for breakfast. Not even the hourly reminder from guards at the jail that the gallows waited for Johnson in the basement of the jail 3 floors below his cell seemed to disturb him. In 1906, counties in Tennessee, not state officials, had to carry out their own executions, and the legally required method was by hanging. If his faith in heavenly things had grown, Johnson's hope in the criminal justice system had completely evaporated. He was resigned to dying. He had accepted the prediction of Sheriff Shipp and other local officials that the Supreme Court would never intervene in his case. When the justices issued no decisions late Saturday or early Sunday, the Tennessee authorities felt secure in their hopes that Johnson would be executed as scheduled on Tuesday, March 20th. Many local lawyers doubted that Johnson's defense attorneys would get the opportunity even to present a petition to the Supreme Court. What no one back in Chattanooga, including McReynolds, Shipp, or even Johnson, knew was that Pardon had been allowed to present the case to Justice Harlan late Saturday evening. He had filed the petition with the High Court, and Justice Harlan had even granted him 10 minutes to argue personally why the Supreme Court should bother with the matter. Now Pardon was on the train headed home. Ed Johnson was oblivious to all that. He was living for the moment, determined to harbor no ill will in his heart. Sunday morning began with more than a dozen local citizens stopping by the jail to have their picture taken with the condemned Negro. They were not his friends or his neighbors. In fact, he never laid eyes on most of the visitors. To them, the photographs were simply souvenirs. The deputies would parade Johnson out of his cell, force him to pose like an animal in a zoo. But he did it without complaint. According to a reporter for the Chattanooga Times who spent the day with Johnson, quote, "A morbid desire seemed to possess large numbers of white people to see the prisoner. Many of them left fruit, sweetmeats, and delicacies, and last night his cell was well filled with the day's offerings. There were numbers of oranges, apples, cakes, and other good things to eat, and books and magazines were also left for him to read. He appeared glad to see all who called, and talked freely when spoken to." Unquote. Even in 1906, prisoners facing death were given one final wish, as long as it wasn't too outrageous. Most condemned inmates choose a favorite meal with family or other prisoners. Some asked to visit a special place, such as Lookout Mountain or their mother's home. One inmate wanted to play an all-night poker game on the eve of his hanging. Ed Johnson's request was a little different. His only wish was to be allowed to attend Sunday morning worship service. He had experienced a religious conversion in the Knox County Jail. Now he wanted to be baptized and share his testimony with other Christian believers. Sheriff Shipp believed Johnson was sincere in his request. He didn't suspect the prisoner was masterminding some elaborate escape attempt. Yet, he was reluctant to remove Johnson from the jail. Too many risks. Too many things could go wrong. Too many people still wanted to lynch the defendant. At the same time, Shipp wanted to accommodate the inmate's request. He had not changed his mind about Johnson's guilt, but he was a Christian man of compassion, and he understood that granting the final request of a condemned man was traditional. The sheriff also had a second motivation in allowing his prisoner to attend a final church service. God might inflict a deep conviction upon Johnson's soul, so that the defendant would publicly confess his sins, including the attack on Nevada Taylor. So, although Shipp wouldn't let Johnson go to the church service, there was nothing wrong with bringing the church service to the jail and to Johnson. Shipp contacted the Reverend W.B. Fleming, a prominent black minister in Chattanooga, and the pastor of the St. James Baptist Church, which Johnson had requested to attend. The sheriff explained the situation. He said Robert Fleming would be allowed to bring the church's choir and several parishioners to the jail. To the great surprise of Shipp, more than 300 members of the black church packed into the eating area of the jail, the largest room in the facility. They overflowed into the jail's lobby and outdoors into the courtyard. Johnson was brought downstairs from his third-floor cell and seated to one side. Sheriff's deputies were placed at each corner and two near the prisoner. They were the only white people in the multitude. Fleming started the service by announcing that they had gathered for the benefit of Johnson. He then led the group in a series of hymns. Johnson had requested that the congregation sing, quote, "There's power in the blood," unquote. Reverend Fleming readily agreed and started the congregation in song. No one sang louder or with more spirit and joy than Ed Johnson, a great contrast to his normally soft-spoken manner. Quote, "Would you be free from your burden of sin? There's power in the blood, power in the blood. Would you o'er evil a victory win? There's power in the blood of the Lamb." The choir sang "Amazing Grace" and "When the Roll is Called Up Yonder." Amid shouts of "Amen," the minister preached a fervent message of heaven and hell, sin and condemnation, mercy and love. The singing, preaching, and reaction from the congregation were so noisy they could all be heard several blocks away. Throughout the sermon, Johnson sat with his hands folded as if in prayer. Asked by the preacher to address the congregation, the condemned prisoner slowly rose to his feet. Tears on his cheeks and a quiver in his voice, Ed Johnson began to speak. Quote, "I've had a change of heart," unquote, he said. Sheriff Shipp and the deputies immediately perked up. Johnson, with tears in his eyes, took a deep pause. The lawmen looked at each other, hoping, thinking the condemned man was about to confess. If he did, there would be much less controversy over his hanging. However, they were quickly disappointed. Quote, "I am ready to die. The change came over me all at once, and I can't tell you how it was. Before the change, I hated the people who were against me. I couldn't eat and could only think of the arrest and the trouble I was in. I didn't want to talk or eat and didn't want to see anyone. All at once, I felt different. I didn't hate white people anymore. I pray every day for Miss Tate, but I am not the one who did those things to her. I am not that man." Started ringing. At that moment, an elderly deacon in the congregation spoke up. Quote, "I move that Brother Ed Johnson be received into membership of the St. James Baptist Church and be accepted as a proper candidate for baptism, since he has here made a public profession of his faith," unquote. Reverend Fleming repeated the motion and asked the audience if anyone objected. There were no votes against. Before Johnson could be made a member of the church, the minister said he had to be baptized. A jumbo-sized bathtub was located at the end of the corridor near Johnson's cell. Deputies filled it with water. Right there in the jail, the preacher immersed Johnson's head under the water and then lifted him out, proclaiming his spirit to be pure and ready to enter the gates of heaven. Quote, "I baptize you in the name of the Father, the Son, and the Holy Ghost," unquote. The pastor said as part of the Protestant ceremony. Quote, "Johnson came out of the water in a paroxysm of emotion. He started down the corridor, clapping his hands, and with his eyes raised wildly toward the ceiling. His conduct further excited the women in the choir, and as they began shouting and singing, 'In the sweet by and by,' some of the women fell prostrate on the floor, one of them apparently going into a trance," unquote. Chattanooga Times, Monday, March 19th, 1906. Late Sunday evening, Noah Pardon stepped from the train depot in Chattanooga, exhausted from his 15-hour trip. After replaying every word and phrase, each expression and argument, Pardon was convinced that his meeting with Justice Harlan the day before had gone as well as it could. But he had left Washington without any indication of how the jurist would decide. The first person Pardon saw as the train arrived at the station was Styles Hutchins. Pardon had never known his law partner to display much emotion. Yet Hutchins wore the biggest grin Pardon ever seen. He was waving a small sheet of paper in the air. Immediately, Pardon knew the news was good. Before any words were spoken, Hutchins hugged the young lawyer and congratulated him on a job well done. Pardon grabbed the piece of paper from Hutchins's hand and read the brief message intently. It was a telegram from Washington, more important, from the U.S. Supreme Court. Washington, D.C., March 18th. To Honorable C.D. Clark, U.S. Circuit Judge, Chattanooga, Tennessee. Have allowed appeal to accused in habeas corpus case of Ed Johnson. Transcript will be filed tomorrow and motion also made by Johnson's counsel for formal allowance of appeal of court. Signed, John M. Harlan, Associate Justice. Pardon reread the telegram to make sure it said what he thought it did. The message was in the typical legalese, but the interpretation was clear. Johnson was not be executed as scheduled on March 20, and there would be a lengthy hearing for the defendant's case in Washington. The two lawyers embraced again. Justice Harlan had notified Federal Judge Clark, State Judge McReynolds, and Sheriff Shipp about the stay of execution via telegram. Hutchins and Pardon also had been sent a copy. The formal paperwork, the court said, would follow in a few days. At that time, the justices would also set a date for oral arguments for both sides. The decision in Washington to intervene in the Johnson matter had not been an easy one. Indeed, it was precedent-setting. In the hours following Pardon's presentation to Justice Harlan, the Supreme Court jurist had read the entire transcript of the hearing held before Judge Clark in Knoxville. Many of the allegations made by Pardon appeared to be supported by the record and did not seem to be disputed by lawyers for the state. The justice was troubled that this conviction had been the result of a rush to judgment, and he definitely believed the appeal raised important federal constitutional issues. Justice Harlan decided late that Saturday night to issue a temporary stay of execution. He believed Johnson deserved a full, impartial trial. Yet, the elderly justice remained reluctant to announce his decision formally. He was unsure if he alone had the authority to grant an appeal and delay Johnson's death sentence. He wanted to confer with Chief Justice Melville Fuller and other associate justices before taking such action. At Harlan's request, a majority of the Supreme Court met Sunday morning at Chief Justice Fuller's home in the Foggy Bottom section of Washington. Harlan gave each of the justices present a copy of Pardon's brief and the accompanying documents. He recited as much of Pardon's presentation as he could remember. To his fellow justices, Harlan made an impassioned plea. He said there was little doubt that Johnson had been denied a fair trial, and he told them about the lynching attempt and the prejudices that permeated the Chattanooga community. The law, he said, was about justice in doing what was right. Justice had not been served. This was the time for the U.S. Supreme Court to send a message to law enforcement and court officials throughout the country that they were expected to obey the spirits as well as the letter of the law. Finally, Harlan told the other members of the court that he believed the defendant was actually innocent of the crime. If Johnson had been wrongly convicted and would hang as a result, the other justices said, the Supreme Court should intervene. They could not allow an innocent man to die, and they could not allow the U.S. Constitution to be trampled underfoot in a sham state court trial because of the racial prejudices of court officials in Hamilton County. Such an act by government could not be tolerated, they agreed. Associate Justice Oliver Wendell Holmes was the first to speak in favor of Harlan's proposal that they accept the appeal. Though he admitted his reluctance to assert federal court jurisdiction in a state criminal matter, he said there appeared to be substantial evidence that Johnson's constitutional rights had been violated. Holmes, a Harvard graduate born and raised in privileged circles in New England, had been disenchanted with the handling of criminal and civil cases across the South. The Johnson matter only reinforced his belief that state courts in the old Confederacy were another means of suppressing black people. After an hour-long discussion, Chief Justice Fuller felt a consensus had been achieved. The justices unanimously agreed on the action that needed to be taken. Fuller told Harlan to proceed with issuing the stay of execution and granting the appeal. The case would be moved to the top of the court's docket, he announced. The Chief Justice also said that lawyers for both sides should file briefs with the court within 30 days and be prepared to argue the petition thereafter. Harlan had not won many of these battles in the past. His usual style was confrontational. In the past, he had argued with the other justices to accept more state court criminal appeals. Each time he was rebuffed. The other justices had been extremely reluctant to interfere in state court criminal cases. But this time was different. On this day, he played the role of coalition builder. The facts were so strong in showing that an injustice had taken place that the other members of the court knew they must act. This time, the United States Constitution and possibly an innocent man's life were at stake. The aging justice immediately walked to the Capitol to formalize the court's ruling. There he took an ink pen to the bottom of the petition filed by Pardon and wrote the court's decision by hand. Quote, "The herein named Ed Johnson asks an appeal from the judgment herein rendered in the Circuit Court of the United States for the Northern Division of the Eastern District of Tennessee of March 10, 1906, denying his application in a writ of habeas corpus. Pursuant to the statutes of the United States, the appeal asked for is hereby allowed. Evidence by my hand as an Associate Justice of the Supreme Court of the United States. Signed, John M. Harlan." Justice Harlan then filled out the formal notice to be delivered to the participants in the case, saying the court had agreed to hear the appeal. The order also told lawyers for the state of Tennessee to prepare to file an answer to Pardon's petition within 30 days. Harlan then instructed the clerk of the court to send telegrams immediately to Judge McReynolds, Sheriff Shipp, District Attorney Whitaker, and the defense team, informing them of the decision. He told the clerk to confirm that the sheriff had received the notice, which officially made Johnson a federal prisoner. And he said that the clerk should make sure that the Chattanooga authorities understood that the Supreme Court was staying the defendant's execution. The clerk agreed to send an additional telegram to the sheriff and judge, making clear the court's order. All further proceedings be stayed, and the custody of the accused retained pending an appeal in Washington. unquote. James H. McKinney, Clerk of the United States Supreme Court. That evening, Harlan walked home. He was feeling pretty good about himself and the court. For 3 decades, he had sat on the nation's highest tribunal. Much of their work involved what he considered to be big business and government. To Harlan, these cases offered nothing of the heart and soul and compassion for the law that he loved so much. In fact, the controversies represented all that was wrong with the world. They were about greed and power. But on this one occasion, in this single case, Harlan believed the court had chosen to do the right thing. They had employed the law to save a man's life. To make such decisions was why Harlan served on the Supreme Court. Such was certainly not the predominant opinion back in Tennessee. The legal community was stunned at the decision. They concluded that, by agreeing to hear the Johnson appeal, the nation's highest court was setting precedent, and they didn't like it. The average person in the city was less analytical, but equally perturbed at the intervention or interference as they viewed it. Throughout the town, people in taverns and coffee shops, restaurants and drugstores took offense at the Supreme Court ruling. This was their town and state, and they resented having people in Washington, D.C. tell them how to run their court system and how to deal with their criminals. The Chattanooga News seemed to encourage vigilantism. Quote, "The gallows in the Hamilton County Jail has again been disappointed in the case of Ed Johnson, convicted by the state courts of rape and sentenced to death. Johnson was told this morning by his jailer of the present status of his case. He said very little except, quote, 'all right,' unquote, in the same tone which was so much noticed during his testimony in the trial of the case. It would be at least 30 or 60 days before Johnson can be legally executed. All of this delay is aggravating to the community. The people of Chattanooga believe that Johnson is guilty and that he ought to suffer the penalty of the law as speedily as possible. If by legal technicality the case is prolonged and the culprit finally escapes, there will be no use to plead with the mob herein another such crime is committed. Such delays are largely responsible for mob violence all over the country." Unquote. Chapter 12. God bless you all. I am innocent. I do not know how much battery I have left.